Hearing the appeal, keen on the application of Pearce and another against Parole Board of England Wales.
Mr. Colby.
My Lords, I'm here for the Appellant, the Parole Board, with my learned friends Miss Sarah Sackman and Mr. Conor Fegan. Mr. Philip Rule appears for the first respondent, Mr. Pearce, with Mr. Jake Rylett, and Mr. Miles Granderson appears for the second respondent, the Secretary of State, although, as I understand it, he doesn't seek to make submissions.
Yes.
This, my Lords, is an appeal in which the parties ask this court to consider the way in which panels of the Parole Board take their decisions. Mr. Pearce is a serving prisoner, having been sentenced to a sentence of imprisonment for public protection in 2010. And the decision in issue is a decision taken by a panel of the board in May 2019, after expiry of his minimum term, that he should not be released. The Court of Appeal held that the panel's decision was lawful. In doing so, however, it considered guidance for panels on aspects of their decision-making process, which had been promulgated by the board following the judgment of the Divisional Court in the case of a man then known as John Radford, but formerly known as John Warboys. The judgment is called D. In fact, the first respondent also refers to a case called D, so I'm going to refer to this case as Warboys to avoid confusion. I'll take you to it in due course. The guidance in issue is directed at the question how panels should deal with allegations made against a prisoner about conduct which has not been adjudicated upon by a court or tribunal. The Court of Appeal considered the guidance and declared that it was unlawful because it contained misstatements of the law, and this is an appeal by the board against that declaration. The appeal gives rise, in effect, to a single issue, which is whether, in discharging its statutory functions, the board may base its decisions only on facts proved to the civil standard, or whether it may also take into account allegations which it considers relevant and which have some evidential basis, but in respect of which it has not found facts proved to the civil standard. And in addressing that issue, I propose to structure my submissions in this way, my Lords. First, to deal with the role and functions of the board and its panels, and I hope to be able to take that relatively shortly and without needing to dwell too long on the authorities, because much of what I have to say, I hope, will be unlikely to be controversial. Second, I propose to deal with the question of what amounts to fair and lawful public law decision-making, because by way of brief introduction, the board's case is that both Mr. Pearce and the Court of Appeal are wrong to say that it's a necessary corollary of the requirements of fairness or of natural justice, effectively that in every case a decision should be based on facts found to the civil standard. And when I address that issue, I'll take you to the authorities from the family jurisdiction relied on by the Court of Appeal and Mr. Pearce, and in particular in Re H, and the authorities to which we've referred the court from the field of national security, and in particular Raymond and Begum. When I have done that, I propose to look at the application of the principles derived from those authorities to the decision-making context of the board. So I start with the board itself, and the starting point for understanding the board's status and role is Section 239 of the Criminal Justice Act 2003, which the court has at page 455 of the electronic file. Section 239(1) provides that the board is to continue to be, by that name, a body corporate, to be constituted in accordance with this chapter, and to have the functions conferred on it by this chapter in respect of fixed-term prisoners, and by Chapter 2 of Part 2 of the Crime Sentences Act 1997 in respect of life prisoners within the meaning of that chapter. And Mr. Pearce is a life prisoner by virtue of Section 34(2)(d) of the 1997 Act, because he's subject to a sentence of imprisonment for public protection. Section 2392 provides that it's the duty of the board to advise the Secretary of State with respect to any matter referred to it by him which is to do with the early release or recall of prisoners. But the word advise there must be understood in the context of Section 28 of the 1997 Act, which is at page 440, and which provides at Section 28(5) that as soon as a life prisoner to whom this section applies has served the relevant part of his sentence and the Parole Board has directed his release under this section, it shall be the duty of the Secretary of State to release him on licence. So in a famous dictum from the case of Brooke, Lord Phillips, the Lord Chief Justice, said that although the original function of the board was to advise the Secretary of State in relation to his exercise of the power to release prisoners on licence, the tables are now turned. The Secretary of State is required to give effect to decisions of the board in relation to the release of prisoners, and the Secretary of State commonly gives the board his own view as to the individual decisions that they ought to reach. So the board, through its panels, is the statutory decision maker which decides whether the prisoner should be released. And the test that it is required to apply in taking that decision is at Section 28(6) of the 1997 Act, page 441. The Parole Board shall not give a direction under subsection 5 above with respect to a life prisoner to whom this section applies unless A, the Secretary of State has referred the prisoner's case to the board, and B, the board is satisfied that it's no longer necessary for the protection of the public that the prisoner should be confined. So the test is whether it is no longer necessary for the protection of the public that the prisoner should be confined. When a prisoner's case is referred to the board, a panel of members of the board is appointed to consider the prisoner's case. That flows from Rule 5 of the Parole Board rules. And Rule 24(6) of the Parole Board rules, page 489, provides that a panel may produce or receive in evidence any document or information, whether or not it would be admissible in a court of law. That is supplemented by Section 2393 of the 2003 Act, back at 455, with apologies for jumping back and forth. Section 2393 provides that the board must, in dealing with cases as respect which it makes recommendations under this chapter or chapter 2 of Part 2 of the 1997 Act, consider A, any documents given to it by the Secretary of State, and B, any other oral or written information obtained by it. So how is the panel required to go about its task of deciding whether it is no longer necessary for the protection of the public that the prisoner should be confined? The nature of the process is of significance for this appeal because both Mr. Pearce and the Court of Appeal rely heavily on the concept of fairness, and as I'll submit, the demands of fairness will depend upon the circumstances and the context of the process which is being considered. So it's necessary to understand the nature of the process before one can address the question of fairness. The authorities are clear that the panel's decision is not the determination of a criminal charge. It is rather a question of risk assessment. For the panel to determine on the basis of the relevant material before it whether the prisoner poses a risk to the public. And it's well summarised by Mr. Justice Elias in the case of Sim, paragraph 60 at page 1409, who said this: "It's in my view important to bear in mind the board is considering a question of judgment which raises many considerations." 1409, paragraph 60. I accept that in many cases they will not be assessing the risk of reoffending directly. That will have been determined by the sentencing judge, but they will be exercising a judgment as to whether the conduct of the prisoner is such that those risks cannot be controlled within the community. That is not simply a factual issue.
Could you give me the page number again?
I'm so sorry, 1409.
1409, thank you. Thank you.
So it's not a purely factual issue, it's an evaluation, and in our submission a particularly sensitive and difficult one. It's an evaluation which requires expertise on the part of the panel members. As the Divisional Court noted in the Warboys case, that's page 646. Paragraph 117. This is a section of the judgment which deals with the issue of irrationality. The Divisional Court said this: the evaluation of risk central to the Parole Board's judicial function is in part inquisitorial. It's fully entitled, indeed obliged, to undertake a proactive role in examining all the available evidence and the submissions advanced. It's not bound to accept the Secretary of State's approach. The individual members of a panel, through their training and experience, possess or have acquired particular skills and expertise in the complex realm of risk assessment. And the court went on to say that the courts have emphasised on numerous occasions the importance and complexity of the role and how slow they should be to interfere with the exercise of judgment in this specialist domain. Rather than read it all out, can I invite your lordships to read paragraphs 118 and 119? In fact, I'd ask the court also to read, there's a quote in paragraph 120, quote from a case called Walker, which is the bottom part of the page. The Divisional Court concluded in paragraph 120 on page 647 that although these general statements were made in the context of the procedure to be adopted in individual cases in discharge of the Parole Board's core function, they should equally apply to this court's approach to the substance of release decisions, so they're dicta which apply both to the procedural and substantive decisions taken by panels. And just to conclude this mini topic of risk assessment, paragraph 133 on page 650. A risk assessment in a complex case such as this is multifactorial, multidimensional, and at the end of the day, quintessentially a matter of judgment for the panel itself. Now, a feature of the panel's process which the authorities emphasise is that it is for the expert members of the panel to decide what information they should consider. You've already seen the dicta of Lord Judge in Walker. Can I ask you next to look at a case called Alvey, which is at page 913. Decision of Mr. Justice Stanley Burton.
I beg your pardon, I missed that page.
913, please. His Lordship stated it's not for this court to substitute its own decision, however strong its view, for that of the Parole Board. It's for the Parole Board, not for the court, to weigh the various considerations it must take into account in deciding whether or not early release is appropriate. The weight it gives to relevant considerations is a matter for the Board, as is in particular its assessment of risk, that is to say the risk of reoffending and the risk of harm to the public if an offender is released early, and the extent to which that risk outweighs benefits which otherwise may result from early release. The same judge, sitting as a Lord Justice of Appeal in the Divisional Court in McGettrick, page 1250, was a case about the panel's ability to choose to exclude information from its consideration. Said this: it's essential to bear in mind it's not the function of the Board to find a prisoner guilty or innocent.
Which paragraph?
I'm so sorry, paragraph 33, page 1250. Essential to bear in mind it's not the function of the Board to find a prisoner guilty or innocent of any offence or other misconduct. Its function is to assess the risk that would be created if the prisoner is released on licence. For that purpose, the Board must take into account hearsay and other evidence of misconduct or criminal offences on the part of the prisoner, whether that misconduct or offence took place before or after or at the same time as the offending for which he was sentenced. Similarly, the Board must take into account evidence as to the relevant good conduct of the prisoner whenever it took place. The weight, if any, to be given to that evidence is a matter for the Board.
Now, what submission was he actually dealing with when he said that, Mr. We find it perhaps just above paragraph 27.
Yes, he's dealing with a part of the case which was about the Board's ability to exclude from its consideration material put forward to it by the Secretary of State.
Well, that's the eventual principal decision, particularly in the Court of Appeal, but at this stage what he's dealing with is this submission, at least if the subheading is anything to go by. The submission of the untried material was a breach by the Secretary of State of a regulation and was therefore unlawful. In other words, they shouldn't have been shown it at all.
Yes. So
and he's rejecting that submission.
Yes, there were essentially two parts of the process which the court looked at in McGettrick. If this material was inappropriate material for the Board to consider, firstly, should the Secretary of State have put it before the Board at all? And secondly, having had it put before them, what should the Board do?
And were they entitled to say, having looked at it, we're not having anything to do with that?
Yes.
Yes.
It's not a straightforward case because the statutory provisions which I took the court to at the beginning of the morning require the Board to consider all documents put before them by the Secretary of State.
Yeah.
The Divisional Court in Warboy said this was a case that had given rise to some difficulty. this part of the judgment is includes material which we rely on essentially for this purpose, which is to show the breadth of the discretion which the board has to decide what material it ought to have regard to and what weight to place on such material as it does have regard to.
Thank you.
The Divisional Court in Warboys, and I'm back now on page 650, addressed this issue under the heading of failure to have regard to relevant considerations. Paragraph 134 on page 650. In fact, that's the start of the section, but what I'd ask the court to look at is paragraph 141 on page 652. The distinction between relevant considerations, properly so called, and matters which may be so obviously material in any particular case that they cannot be ignored is not merely one of legal classification, it has important consequences. If a consideration arises as a matter of necessary implication, because it's compelled by the wording of the statute itself, the decision maker must take it into account, and any failure to do so is without more justiciable in judicial review proceedings. If, on the other hand, the logic of the statute does not compel that conclusion, or in the language of Lord Justice Laws in a case called Khatun, there's no implied lexicon of the matters to be treated as relevant, then it's for the decision maker and not for the court to make the primary judgment as to what should be considered in the circumstances of any given case. The court exercises a secondary judgment framed in broad Wensbury terms if a matter is so obviously material that it would be irrational to ignore it. And McGettrick, which I took the court to a few moments ago, is dealt with in a little more detail in Warboys. Can I ask the court to turn to page 655? And to read for yourselves paragraphs 153 and 154, please. And the conclusion of the court from that material is at 155, drawing these strands together. Whereas we agree with Mr. Collins that it's not the role of the Parole Board to determine whether a prisoner had committed other offences, we cannot accept the extension of that submission shared by Mr. Fitzgerald, albeit advanced in slightly different terms, that it is precluded from considering evidence of wider offending when determining the issue of risk. And they go on to say a few lines further down, as for the submission that the distinction between taking account of evidence of wider offending and refraining from making determinations about it is artificial, we cannot agree. It is important. At the risk of repetition, in the circumstances of the present case, this evidence or material could have been used as a means of probing and testing the honesty and veracity of Mr. Radford's account.
So where does that leave the board, Mr. Collins, in relation to material of this kind? One, they've got to look at it if the Secretary of State gives it to them because of Section 239(4), or
yes.
is it 6, one or the other anyway? Section 239, yes. Two, if they, having looked at it, decide that it's something that they're not prepared to take into account, they're entitled to say that.
Yes.
But three, subject to irrationality, which is what the Divisional Court in Warboys said had happened in that particular hearing.
Yes.
Is that roughly right?
It is, yes. So the board concluded that it was necessary for, the Divisional Court concluded that it was necessary for the panel to make further inquiry about further matters in the Warboys case. And the failure to do so meant that they'd left out of account material which needed to be taken into account.
Yes, but the basis of the decision is irrationality, isn't it?
Precisely. Subject to that problem, then it's a matter for the board what approach it takes to the material, what it makes of it, what reliance it places upon it. There's another short passage in paragraph 150 where the Divisional Court describes this as, in terms of evidence of other offending, being able to be considered as part and parcel of a global assessment of risk. But it's the panel, the expert panel, whose task is to decide what material it relies on, what material it concludes to be relevant or irrelevant, and if relevant, what weight it places upon it as part of that global risk assessment, subject always to the constraints of rationality. So the Divisional Court drew a distinction between making a determination whether a prisoner has committed other offences and considering information about those allegations. And those are part and parcel of the expert judgment of the panel. The authorities emphasise the importance of ensuring the widest possible information is available to the panel, the Divisional Court of Warboys particularly emphasised the use of the word information as being wider than evidence, really simply as we would suggest to make the point that it's important for the panel to have the widest possible material available to it. And we cite some short dicta from a number of other cases in our case, which I don't propose to take up the time of the court by going to individually, but it's set out on page 78 of the file in our case, at paragraph 34. A series of dicta all pointing in the same direction, we say. So, Brooks, for your note, page 593. The panel is entitled and indeed bound to have regard to all relevant information placed before it, including hearsay. McGettrick, page 1259. It's essential the panel should have before it all information that bears upon its consideration of the risk to the public of the prisoner committing further offences if he's released. Harris, which is a case we've not been able to track down, but it's cited in McGettrick at 1259. It's incumbent upon the Parole Board to have before it the widest possible information, and Lichniak 1607, an administrative process requiring the board to consider all the available material and form a judgment. And the court will have detected from a number of the dicta that I've referred to that it's agreed that that can include hearsay material, provided that the hearsay is dealt with fairly. Now, the final aspect of the process that I need to deal with in order to provide the context within which the court will consider the lawfulness of the guidance is the application of the statutory test, that it's no longer necessary for the protection of the public that the prisoner should remain confined. And that test requires the panel to proceed on the basis that the need to protect the public is paramount. And there are a couple of dicta that I'd ask the court to look at in that regard. Firstly, Watson, page 1624. This is a passage from the judgment of Sir Thomas Bingham, the Master of the Rolls, right at the bottom of the page at letter H, number 4. In exercising its practical judgment, the board is bound to approach its task under the two sections in the same way, balancing the hardship and injustice of continuing to imprison a man who is unlikely to cause serious injury to the public against the need to protect the public against a man who is not unlikely to cause such injury. In other than a clear case, this is bound to be a difficult and very anxious judgment, but in the final balance, the board is bound to give preponderant weight to the need to protect innocent members of the public against any significant risk of serious injury. That's the test which, and the references there, you can take as references to the sections that we're considering in this case. The other authority that I rely on to address this point is King, page 1167. Judgment of Lord Dyson, sitting as Master of the Rolls, where he deals with the words paragraph 31 towards the bottom of page 1167. The words necessary for the protection of the public do not entail a balancing exercise in which the risk to the public is to be weighed against the benefits of release to the prisoner or the public. The concept of protecting the public does not involve any kind of balancing exercise. It simply involves safeguarding the public from the danger posed by the prisoner. As Mr. Grzyński puts it, the goal to be achieved is clear, namely the protection of the public, and the means by which it is to be achieved, namely by continued confinement of the prisoner, is equally clear. If the board concludes that confinement is necessary because there will be a more than minimal risk of harm if the prisoner is released, then confinement of the prisoner will be required to avoid that risk. But what the statutory test does not do is to establish a burden of proof. And our submission is that the concept of the burden of proof is not one which is helpful for the purposes of risk assessment. And that was the approach taken by the Court of Appeal in a case called Brooks at page 588, paragraph 28, addressing the criteria which the board has to apply, which are now to be found in section 28(6)(b) of the 1997 Act, and the court can see the quote there.
Whose judgment is this?
So sorry, that is from the judgment of Lord Justice Kennedy, my lord.
Yeah. This is the hearsay case, isn't it? This is the case which establishes that the board can take into account hearsay.
It's one of the cases which establishes that proposition.
Quite. And it's also the one in which Lord Justice Wall coming from the family division, drew an analogy with 3H.
Yes, and that's a matter which I'm conscious I'm going to
course.
deal with. If I may, I'll deal with it at the part of my submissions where I'm focusing on H.
Yeah.
Paragraph 28 assists us with the proper approach to the test. At the bottom of page 588, the Court holds that insofar as it's relevant to do so, the Parole Board applies the civil standard of proof, not determining a criminal charge. It's concerned with the assessment of risk, a more than minimal risk of further grave offences being committed in the future. And as Judge Bing said, in the present case, ultimately the burden of proof has no real part to play. There's a quote from Sim, where Lord Justice Keane said the concept of a burden of proof is inappropriate where one is involved in risk evaluation. And the Court expresses the conclusion that what the Parole Board must do is to decide, in the light of all the relevant material placed before it, whether it is satisfied as envisaged by Section 28(6)(b) of the 1997 Act. My Lords, having undertaken that rather whistle-stop tour of the authorities, we invite the Court to have regard to the following propositions in assessing the guidance which is at the heart of this appeal. Firstly, the panel's function is the acutely complex and difficult task of assessing risk. Secondly, in order to perform that complex function, it is important that the panel considers the widest possible range of information. Thirdly, that it's also important that the panel has specialist expertise so as to be able to weigh the significance of that information for the purposes of the statutory test. Fourthly, in undertaking its task, the panel must give preponderant weight to the need to protect the public.
May I ask, why preponderant weight? If the statutory test is to decide whether it's no longer necessary for the protection of the public that the prisoner should be confined, if that is the relevant question, why is...
My Lord's right, I suspect, save insofar as the panel will weigh all of the material before it that it considers to be relevant. But the question that it answers is, how do we protect the public?
Yes. So it's not a preponderant question.
It's not. I've perhaps lazily borrowed that word, I suspect, from one of the dicta that I've read to your lordships this morning.
Sir Thomas Bingham's in what?
Well,
actual source.
This Court may feel able to say that Sir Thomas got it wrong. It's not for me to do so in my submissions.
But Lord Kitchen's point surely is a valid one.
Yeah.
The need to protect the public is the test.
Yes.
It's not a factor that's been given weight.
Yes.
He was dealing, wasn't he, with the suggestion that it's always a balance between the benefits to the prisoner of release and the dangers to the public if he's released. And that's dealt with in one of the quotations which you gave us just recently. Yeah. Effectively, it isn't. It's Lord Dyson, isn't it? It's not really a balance. Exactly. It's a question of weighing up what the risk to the public is.
And if there is a more than minimal risk to the public, the panel effectively has no option. The panel is required to determine that the confinement should continue. Notwithstanding that, I mean, I recognise that there may be benefits to the public as well as the prisoner in some cases from release, because that enables testing and rehabilitation and so on and so forth. But whatever materials may be in the balance, if the ultimate conclusion is that there's a more than minimal risk to the public, that's the end of the decision, in effect. So my fourth proposition properly needs amending, and I'm grateful to my Lord for that. The final proposition is this, that given the complexity of this evaluative process and given the particular expertise of the panel, courts are slow to intervene in decisions either as to process or outcome, in particular as to the information to be considered. My Lords, that's the context in which we invite the court to have in mind when considering whether the board's approach, as set out in the guidance, is fair and lawful. It leads me to the second part of my submissions, which is the consideration of the proper approach as a matter of public law to a public law decision maker in general terms, of which the board, of course, is one particular species. And I start with this submission that we respectfully submit that, contrary to the way the case is framed by both the first respondent and indeed the judgment of the Court of Appeal, this, in our submission, isn't really a case about fairness in the public law sense at all. It's really about identifying what material is relevant and appropriate for a public law decision maker to take into account. And it's possible, we say, to apply a conventional public law approach to the board's decision-making role along the lines of this, that the board must consider the widest possible range of information. It must determine, using its expertise, what of that information is relevant. If a piece of information is relevant, the panel must determine what weight to place on it. Again, no doubt using its expertise. And taking all the relevant information together, it must weigh it in reaching a conclusion on the ultimate task of risk assessment. Its determinations on the issues of relevance and weight are subject to the usual public law constraints, including in particular irrationality. But we respectfully suggest that when one has that perhaps orthodox framework in mind, a broad-based appeal to concepts such as fundamental principles of the common law or common law fairness doesn't really assist with a proper analysis of the lawfulness of a decision taken in this way. Nor, we would suggest, is it helpful to introduce the concept, as the first respondent seeks to do, of facts and non-facts. And I want to deal briefly with that issue, the issue of fact-finding. Now, fact-finding is, in one sense, always artificial, because there is rarely certainty as to what happened in the past, and there is never certainty as to what will happen in the future. So if, when the respondent uses the expression non-fact, he means something that didn't happen, well, that's no more capable of identification with certainty than is a fact. What decision makers, and in particular judicial decision makers, do, of course, is to apply a system whereby certain facts are treated as though they certainly did or did not happen. So in the criminal context, if the jury or magistrates are sure something happened, the possibility that it did not is discounted. And in a civil claim, if the judge thinks it more likely than not that something happened, the possibility that it did not, and of course in some cases under that test there'll be a very significant possibility that it didn't happen, but that possibility again is discounted. And once one recognises that, in our submission, the use of the term non-fact really is an entirely circular argument. A non-fact means something not found to be a fact to the civil standard. It doesn't tell us anything at all about whether the civil standard should be applied or not. The question for this appeal is whether that system with which we are all so familiar, the discounting of matters which are not proved on the balance of probabilities, question is whether that system is a necessary part or a necessary minimum part of the board's decision-making process, or, as in fact we understand it to be put by the first respondent and the judgment of the Court of Appeal, of any public law decision-making process. And we respectfully submit that there's simply no authority that's been identified, no authority before this court to the effect that the application of the civil standard of proof is a necessary minimum requirement of every public law decision. Our submission, in short, is that there is no such requirement. The requirements are familiar. The decision maker must have regard to all relevant material and no irrelevant material. They must apply the law correctly. They must act rationally. If those requirements are met, that is sufficient. And that is why, in our case, we have relied on Lord Justice Singh's caution against the use of the term public law fairness in Talpada, which is in the bundle at the relevant section 1447. Before I ask your lordship to read the passage that we have in mind, can I say this? This isn't an arid or an academic point. It highlights in our submission the lack of a proper basis for criticising the board's guidance. The section which we invite the court to consider starts at paragraph 55, where Lord Justice Singh indicates that he would like to add some observations in relation to two matters: the concept of fairness in public law, and secondly, the need for procedural rigour in public law litigation. And can I ask the court to read paragraphs 56 to 58, please? I will tell Parder was a case about a decision to refuse leave to remain. And the observations of Lord Justice Singh seek to draw a distinction there between a complaint which was framed as one of procedural fairness but was in fact about the substance of the decision. And we make a submission along similar lines in this case. The complaint in this case is not in reality about procedural fairness at all. It's about the substantive question whether the guidance requires panels to take into account matters which are irrelevant. And I should say in this regard, the first respondent, I note in his case, takes issue with the submission in our case that in the present case there wasn't a complaint of procedural fairness and flags up that it was described as such. And I accept that the first respondent described his complaint as one of procedural fairness, but for the reasons given, we say it's not properly treated as an issue of procedural fairness at all. The prisoner was aware of the material before the board. He was given an opportunity to address it. His complaint is not about the procedure. It's about the substance of the decision.
Yet it includes a complaint about the route and to that extent the procedure by which the decision was arrived at, doesn't it? That I suspect is what Mr. Rule means.
So the complaint, as we understand it, is the taking into account of matters not proved on the balance of probabilities. And I can see how that might be described as procedure with a small p, if I can put it that way. It's not a complaint of procedural fairness in public law terms.
Not in the sense that Lord Justice Singh describes it, which is what some of us were brought up to call the rules of natural justice.
Yes. And natural justice is a concept which is invoked in my learned friend's case. And we say it's that the reliance on it is misplaced in the circumstances of this appeal. Of course, it's right that the Court of Appeal in this case concluded that there was a failure to act with fairness. And I should take the court to the relevant part of the Court of Appeal's judgment. It's in the core volume at page 162. It's right at the top of the page. It's the last few lines of paragraph 43, where Lady Justice Pearce says, "I cannot conceive how the touchstone of public law fairness can operate in the circumstances in which an allegation which is not proved on the balance of probabilities is taken into consideration in the assessment of risk." And we respectfully suggest that conclusion can only presuppose a requirement in relation to all public law decisions that facts be found on the balance of probabilities and that no other matters be taken into account. But as I've already submitted, we identify no authority for the proposition that that approach applies across the board to every public law decision. Of course, we accept that it's been found to apply in some contexts, and I'll deal with that. But we identify no authority which identifies such a blanket rule, and we say that's unsurprising because the requirements of fairness will inevitably be specific to the context and in some respects also the particular case. And in case
the board is exercising judicial decision making.
Yes,
Yes.
it is. And of course I accept that most judicial decision makers use the balance of probabilities, either the civil or the criminal standard, but not all of them, and not necessarily, as I hope to explain in the course of my submissions.
May I ask this, in relation to this sort of assessment, what is or is not a fact? Because one may say the fact that an allegation has been made is itself a fact.
It is in one sense a fact. it's a fact which the board takes the view can never of itself be sufficient to found a conclusion about risk. But yes, it is. It's a fact in one sense.
Now, if one has two allegations and they're independent, then that's two facts. There's a third fact, which is that both allegations have been made and they're independent.
Yes. The board seeks a little more than that. And again, this is a question of rationality for the board to decide what approach to be taken. And of course, I will take the board through the guidance in some detail once I've laid the groundwork for the approach that we invite the court to take. Where there are only allegations with no further evidence to support them, the board's approach is that that will never be sufficient.
No matter how many there are?
I think that must be right. The probability of there being a substantial number of allegations and no other facts which could be found in relation to them may be limited. But the guidance certainly indicates that where an allegation is unsupported by any other evidence, then that is not a matter on which the panel should place weight.
But would the existence of another allegation potentially support the first allegation? I'm thinking of certainly in Scots criminal law, the doctrine, the Murroff doctrine, that's similar. In that case, obviously, it's criminal evidence. It's evidence of similar fact, course of conduct. By complainer A, complainer B, complainer C provides what in Scots law is seen as the needed corroboration of the complaint in question. So in the context of the Murroff doctrine, the fact that someone else has said a similar thing happened is itself a fact.
And later on in my submissions, I'm going to come to Lord Brown Wilkinson's rather vivid analogy of the aircraft in 1940 overhead. And that analogy is vivid because there are five unconfirmed sightings rather than one. So it is perhaps obvious that panels are going to have regard to the extent of information and whether information is supported by other information. And of course, the more allegations that they are, the more they tend to support one another.
Yes, so another allegation may be a fact which supports the first allegation.
It may
even if there is no fact about the first allegation to support it itself.
My only hesitation is that the board does not. The board's guidance does limit the panel to this extent that it indicates that there must be some evidence, some evidential material upon which for it to base its decision.
Certainly for my part, I'd welcome a little bit of assistance as to what that contemplates, but you're going to come to that in due course.
It may be that it's easier for me to deal with that question when I come on to deal with the sorts of decisions that the board takes itself.
Please do.
And there are a number of cases which I hope to give the court a feel for the way in which these principles are put into practice by panels themselves. The reality is that in most cases there is material upon which panels find facts. And of course that happened in this case, in Pearce. That's why Mr. Pearce's appeal to the Court of Appeal was dismissed, because there were facts which were found. So it's going to be a relatively rare case where there are no facts at all. But if I may come back to illustrate with more concrete examples later on in my submissions, it may be easier to follow that.
But your case is that there's no need actually to find any facts, in theory anyway.
In theory, that's right. Yes. Because the board can weigh in the balance evidence, information, material which assists it in reaching an evaluation about risk, even if there is no single matter which can be proved on the balance of probabilities.
Well, if it can't, then that's one question. But are you going to be suggesting to us that they don't need to try?
No.
Right.
No, I'm not going to suggest that. It is...
If they can find facts, they should.
Yes.
Within perhaps some limits, because a substantial trial of what would otherwise be a criminal allegation might involve the board in a fairly complex evidential exercise. But anyway, in principle, you say they should try.
They should try. And I wonder, as I hear these questions coming from the court, if actually I should show you the guidance before I continue my review of the principles that apply. And I'll ask the court to do that now, and it may make my submissions easier to understand when you have the guidance in front of you, or have at least had a chance to review it. It's in Appendix Part 2. The version that we'll ask you to look at starts at page 429. The document that you have there is a consolidated version because the original guidance was issued in March 2019. This is a track changes version, so you can see what was added in July 2021. Court of Appeal had regard to the most recent version. And we start on page 431 with the introduction that panels may be presented with allegations that have been made, and an explanation at 2 that allegation refers to conduct alleged to have occurred which has not been adjudicated on by a criminal or civil court or a prison adjudication. It notes that allegations which are relevant are those which, if true, could affect the panel's risk analysis. Sometimes they're currently being investigated by the police or others and may be disposed of or adjudicated on in the future. They may be of harmful behaviour and risky behaviour. And once it's established that an allegation has been made, panels will need to consider it when making a parole decision. And the last paragraph of the uncontroversial section, if I can put it that way, number 5, decisions must be made objectively based on the information and evidence provided to the panel as a result of its inquiries and what can properly be inferred. All of that is not in dispute. Paragraph 6 is where we begin to deal with what is before this court. Panels faced with information regarding an allegation will have to assess the relevance and weight of the allegation and either A, choose to disregard it, or B, make a finding of fact, and C is the part with which the Court of Appeal took issue, make an assessment of the allegation to decide whether and how to take it into account as part of the parole review. So C deals with the situation where a panel has not simply disregarded the allegation, but it's not made a finding of fact. It then has to decide whether to take it into account. It doesn't have to. That's part of its expert task. If it does, it has to decide how to do so. And then paragraph 7 deals with the need to record their analysis and conclusions. There's then a section on relevance, again, which is not controversial, and it identifies the sorts of matters which may be relevant: harmful behaviour, risky behaviour, allegations that undermine the credibility of a prisoner as a witness, allegations relating to reliability to comply with licence conditions, or allegations that impact on the weight the panel gives to the evidence of a professional witness who wasn't aware of them. Where allegations are found to be relevant at paragraph 9, this is really an echo of paragraph 6. Panels need to either disregard it or make a finding of fact, or 3, make an assessment of it. So 9.3 effectively is the same as 6C, or it reflects it. Paragraph 10 correctly identifies that panels should disregard an allegation which is not relevant, but they should usually make findings in respect of allegations which they consider to be relevant. And that may be an answer to my Lord Hughes's question about whether they should try. Said they should usually do so. And it says, as is perhaps obvious at the end of the paragraph, a panel should give no weight to an allegation that is disregarded. Findings of fact are addressed in the next section. Panels may need to make a finding of fact regarding the allegation when it's capable of being relevant. A panel is in a position to make a finding of fact, that is, when there's a sufficient body of evidence to allow it to make a finding on the balance of probabilities. And importantly, C, the prisoner's case can be fairly considered, that is, a fair opportunity to contest. Some cases that will require an opportunity for cross-examination, some cases it will require an oral hearing, but that will all depend on the circumstances of the case. And at 12, it is possible to make findings of fact on allegations where the individual was not charged or not convicted, provided always that it's possible for the prisoner to have a fair hearing in relation to them. A finding of fact at 13 doesn't equate to a criminal conviction. And recall cases are addressed at 14. And at 15, panels must apply the balance of probability test when making a finding of fact and should remember the burden of proof is not on the prisoner. There's an injunction about being careful about making findings of fact in relation to allegations that are being investigated. And then at 17, having made a finding of fact, the panel will need to assess how it's relevant and what weight should be given to it. All of that, again, relatively uncontroversial. It's the next section which gave rise to concern for the Court of Appeal. And it's headed Making an Assessment of the Level of Concern. And it says that panels may need to make an assessment of an allegation when the allegation is capable of being relevant to the parole review, but the panel is not in a position to make a finding of fact, either because there's insufficient material available on the balance of probabilities or because it would not be fair to do so. Most often, when there's information but critically important aspects of the evidence cannot fairly be tested. Just to give you a flavour of the sorts of examples, a complaint of violence where the complainant has withdrawn their cooperation, doesn't wish to provide a statement, for example, might be an example of that. The allegation and the circumstances around it can form a basis for testing the reliability of the prisoner's evidence. Wider circumstances may also give rise to areas of concern. And then the final part of the paragraph, which was added in 2021 following concerns by Mr. Justice Bourne in this case and the Divisional Court in Morris. In cases where there's a mere allegation without any factual basis that can be identified by the panel, or the allegation is irrelevant, the allegation should be disregarded and no weight placed on it. To make an assessment of concerns arising from an allegation, panels will need to decide what, if any, relevance the allegation has and the weight to attach to the concerns, and then form a judgment as to the relevance and weight, if any, to be attached to the concerns and the impact this has on the panel's overall judgment. So at the end of all of that, of course, it's open to the panel to conclude that it won't attach any weight to it because, in fact, notwithstanding that there is some evidence, it doesn't take their decision any further. Paragraph 20, if an allegation is relevant, the panel will need to form a judgment as to what weight to give the allegation. This will require an examination of the allegation and any underlying facts that the panel can find on the balance of probabilities. So there are two things that the panel must do. It looks at the facts that it has found on the balance of probabilities, but it will also look at the allegation. And as I've already submitted to the court, the assessment of weight is absolutely classically a matter for the expertise of the panel itself, but there are 6 items which the court may feel are relatively obvious in terms of the sorts of matters that the panel will take into account when considering weight. I'm going to come back to one of them, nature of the allegation, because the Court of Appeal was particularly concerned about that one. But to foreshadow my submission will be that it's entirely obvious and correct that an allegation of more serious misconduct is capable of having a greater effect on the panel's risk assessment. And the concern expressed by the Court of Appeal about the effect of that, with respect, tends to indicate a failure to appreciate the nuanced process that the panel has to go through. We then have what are really consequential paragraphs of the guidance. Having analysed the relevance of weight, the panel should reach a judgment about the impact the level of concern has. 22, that requires the panel to draw on its skills and experience to form a view about the level of concern that should attach to the allegation and how that then impacts on the parole review. 23, again, perhaps obviously, an allegation that's relevant and of significant weight is likely to be a matter of concern, whereas 24, an allegation that's only marginally relevant or which carries little weight is likely to be of little concern. And then this added in 2021, mere allegations without any underlying factual basis or irrelevant allegations should be disregarded. The panel's risk assessment should always be based on found facts, even if they're unable to make a finding of fact about all the matters raised. And then the requirement to give reasons.
So when was that last bit added?
It looks like it's in two different colours, but I think it's not. It's not intended to be. I think it's all added at the same time in July 2021. I'm grateful to Mr. Rule. He tells me that it is meant to be two colours. One deals with dicta from this case and one deals with dicta from Morris, but they're done at the same time. I hadn't appreciated that, but we can see from page 430, paragraphs 15, 18, 20 and 24 amended to reflect judgments in the cases of Morris and Pearce.
So if you succeeded on this appeal, would that last sentence be removed?
My Lord, no, because these were added in response to the judgment of the High Court in Pearce, which upheld the approach taken by the board. What the board has not done is to produce a yet further set of guidance in light of the Court of Appeal's decision, with some gratitude to this court for hearing this appeal on an expedited basis. This guidance is not currently in force because of the judgment of the Court of Appeal.
Because I'm having the panel's risk assessment should always be based on found facts. Exclusively on found facts?
No. So there
must be some found facts in addition to the original offence.
Paragraph 24, that the risk assessment requires some facts to be found.
But other matters can be taken into consideration as well.
Yes.
Which, if they hadn't been taken into consideration, might have led to a different decision.
Yes.
Yes. I see.
The extreme end of that being a case like War Boys, where it's concluded that it's irrational not to have taken into account further matters which have not been the subject of a determination by the court.
And should we understand from your earlier submission to us that by some found facts, you don't include allegations as such?
My Lord, no. I'm just trying to find the relevant passage which makes that clear. It's paragraph 18, where there's a mere allegation without any factual basis that can be identified by the panel. The allegation should be disregarded and no weight placed on it. So there will always have to be something more on this guidance. And as I've submitted, I suspect the reality is the prospect of there being nothing more is remote. But it's an attempt, as I understand it, on the part of the board to ensure that the decision-making process is grounded, firstly, in an attempt to find facts, and secondly, that there is at least some factual or evidential basis for the conclusions that are reached.
Thank you.
So, my Lord, I hope that makes the submissions of principle which I've been making thus far, and which I'm going to go on to continue. I hope that gives them perhaps a little more context than they might otherwise have had. What I was dealing with before I turned to the guidance was the proposition that the requirements of fairness are inevitably specific to context, and in particular to the context of the particular case. And in case of doubt about that proposition, can I take the court to a case of Appellant, which starts at 1312. It's a case about a refused application for leave to remain. And there's a section which starts on page 1328. Which, first of all, this is from the judgment of Lady Arden. Which the other justices agreed with, certainly this part of the reasoning. She first of all, at paragraph 53, confirms that she doesn't seek to depart from Lord Carnwath's judgment in Gallagher Group, where he said that procedural fairness is well established and well understood, but substantive unfairness, on the other hand, is not a distinct legal criterion. It adds nothing to the ordinary principles of judicial review, such as irrationality and legitimate expectation. It's by reference to those principles that cases such as the present must be judged. And then at 55, procedural fairness is adaptable to the environment in which it's applied. It does not entail that the decision maker must comply with a pre-designed set of rules. And the court, I suspect, will be very familiar with what Lord Mustill said in Ex parte Duty, but it's relevant to consideration of this case, where he asked what fairness requires. And he refers to the authorities in which the courts have explained what is essentially an intuitive judgment. So firstly, where an Act of Parliament confers an administrative power, there's a presumption it will be exercised in a manner which is fair in all the circumstances. Secondly, the standards of fairness are not immutable. They may change with the passage of time in the general and the application to decisions of a particular type. Thirdly, and this we say is relevant to our case, the principles of fairness are not to be applied by rote identically in every situation. What fairness demands is dependent on the context of the decision, and this is to be taken into account in all its aspects. An essential feature of the content is the statute which creates the discretion as regards both its language and the shape of the legal administrative system within which the decision is taken. And then fifth is having the opportunity to make representations, and sixth, the need to understand the case against the individual. The reference to the statute is a matter that I'm going to come back to, because the case of In Re H, the family case, which is relied on by the Court of Appeal in reaching its conclusions, and which Mr. Pearce relies on heavily in this appeal, is grounded in a very different statutory regime than the regime we are looking at in the present case.
This is all in the context of procedural fairness.
Yes.
Yes. It is, and I seek to deal with the question of fairness insofar as I can do. The court has my submission. It's not really what we're looking at here.
Yeah, yes, I see.
But I need to address the judgment of the Court of Appeal, which
Yes.
Which does purport to rely on it. The key paragraph in the judgment, if I could take the court back to the core volume, paragraph 35 of the Court of Appeal's judgment, page 160, 160. where the Court of Appeal considers what constitutes a fair procedure, it's the second line, to make findings of fact or evaluations of the information. The Court of Appeal says it will be fact-specific, as explained in West, and is unlikely to entail the formality of public law family proceedings, which we take to be a reference to In Re H. Then refers to a case called Considine, which I'll come back to, which it takes to be authority for the proposition that a fair analysis of all the information should inform the necessary judgment in relation to risk. That's relatively uncontroversial. And then the second part of the paragraph in our submission is much less grounded in authority. And the learned judge says, what is clear to me is the panel must conscientiously evaluate the information before it to make findings of fact upon which to make the assessment of the prisoner's risk. In these circumstances, neither public protection nor public law fairness will be compromised. Established or undisputed constituent or consequential facts to an overarching allegation may provide compelling and convincing indications of risk in themselves, whereas simply to assess the seriousness of the nature of an allegation, provided there is some evidential basis for it, is to embark down the route of no smoke without fire. And that is the part of the judgment, so far as this submission is concerned, with which we take particular issue. To describe the evaluative task which the panel undertakes as, in effect, a crude no smoke without fire decision doesn't do justice to the nature of the task or the nature of the panel. I've addressed the court already on the concept of public law fairness and the difficulty of applying it to present circumstances. And we say that while the first part of the paragraph is correct and founded correctly in authority, the conclusions in the second part of the paragraph are not founded in authority and are not correct. I should deal with the reference there to the case of Considine. That's at page 1579. And it's a case about criminal sentencing, and in particular the assessment of dangerousness when sentencing in accordance with Section 229 of the Criminal Justice Act. And I won't ask the court to leap around in the bundles and look it up, but for your note, Section 229 is in the electronic file at page 453. And there are plainly some similarities, and the Divisional Court in Warboys certainly concluded there are some similarities between the process of assessing the dangerousness of a convicted criminal for the purposes of Section 229 and assessing the risk to the public by a panel of the board under Section 239. The relevant section which is referred to by the Court of Appeal is paragraph 37. That's what's mentioned at paragraph 35 of the Court of Appeal's judgment. Paragraph 37 is on page 1579, and we draw the court's attention to how that paragraph starts. It starts with the court indicating that we have, and it's a judgment from a 5-judge Court of Appeal. We deliberately declined to lay down any hard and fast rules about how the court should approach the resolution of disputed facts when making the Section 229 assessment. Goes on to say, in reality, there'll be very few cases in which...
Sorry, where are you reading?
I'm so sorry, it's paragraph 37 on...
37, right,
37.
sorry. Right.
That's my fault, my lord. I was taken to that paragraph by paragraph 35 in the Court of Appeal's judgment in this case.
Yes, right.
I may have muddled the court. Apologies if so. So 37. We deliberately declined to lay down any hard and fast rules about how the court should approach the resolution of disputed facts when making the Section 229 assessment. In reality, there will be very few cases in which a fair analysis of all the information in the papers prepared by the prosecution, events at trial if there has been one, judicial assessment of the defendant's character and personality, always a critical feature in the assessment, the material in mitigation drawn to the attention of the court by the defendant's advocate, the contents of the pre-sentence report, and any psychiatric or psychological assessment prepared on behalf of the defendant or at the behest of the court itself should not provide the judge with sufficient appropriate information on which to form the necessary judgment in relation to dangerousness. There are echoes of that approach we would submit in the task of the board. Echoes in that there is a wealth of material which may be available. It is important for the sentencing judge to have regard to as much of that material as possible. And in reality, in most cases, there will be sufficient appropriate information upon which to form a judgment. But that doesn't take us any further forward. The Court of Appeal took that to be a matter which supported its proposition that one needed to make findings of fact to the civil standard. And Considine doesn't begin to say that. On the contrary, it simply says that there are no hard and fast rules about how the court should approach the question. The court in Considine was clear that it wasn't a hard and fast requirement that there be a conviction or a judicial adjudication of some sort, but it doesn't deal with a requirement to find facts to any particular standard. And that, we say, is consistent with our submission that there simply is no universal rule.
Mr. Collins, am I right in vaguely remembering that at least in one of the cases that was considered in Considine, the trial judge, or rather the sentencing judge, faced with suggestions that the defendant had done a number of things which weren't on the indictment, had embarked on what's known in the trade as a Newton hearing?
Yes.
In other words, he'd heard evidence. Yes? Did the court have something to say about that?
It did. It's paragraph 31. The case is Farrer. It may be that I need to go further back in order for this to be clearly explained. Let me go right back to the beginning. I won't go through all of this, but paragraph 23 on page 1575 identified the question, which is whether the assessment of dangerousness was based on inadmissible material. Over the page at 26, there's a note that the critical recurring word is information, and 27, that's not restricted to evidence. And there is then a practice note identified at 28. And the case of Farrer, which is referred to at 29, is the case, and we can see this at the top of 1577. There was an allegation of an incident with similar features 9 months earlier. Defendant disputed the allegation and wasn't charged. The earlier incident was of obvious potential relevance, and just alongside B, the judge decided he would determine the issue as a form of Newton hearing, and he determined that he was satisfied the earlier incident had taken place. And it was argued that, in accordance with a case called Kidd at paragraph 30, that a defendant is not to be convicted of an offence unless his guilt is proved.
Because otherwise what you're effectively doing is convicting him without the courtesy of a jury trial.
In effect.
Quite. But if you come to 34, I think you'll see where they come to.
I'm going to pause en route to 34 at 31, if I may, where Mr. Justice Mitting concludes that the exercise, which affects magistrate trial by judge alone, was wrong.
Yeah.
And it says at 34 then that what FARA prohibits is the introduction of a hybrid arrangement, the possibility of conviction or effective conviction by judge alone in the course of a sentencing decision, and a Newton hearing is not an appropriate way to deal with that.
Right.
All of that feeds into the conclusion at 37 via paragraph 36 at the top of 1579, where the court says what FARA does not decide is that absent a conviction, the court is precluded from considering evidence of previous misconduct.
That's it.
So a formal finding, a determination of guilt in relation to that allegation was not an appropriate thing for the judge to do. But the sentencing judge is entitled to look at all the material, including other allegations, and all of those items on the list at paragraph 37, which I started with. And it's another reason why we say this case has echoes of the way in which the Parole Board must go about its task. It does not and it may not convict the prisoner of further offences, but it must take all relevant information into account. And it's another example of a context in which we say one can see there's no universal requirement for fact-finding to the civil standard whenever a public or judicial decision-maker is reaching a conclusion. And the court will have seen that in addition to the criminal cases, we rely on two national security cases decided in this court, Raymond and Begum, where a different approach was taken. And I propose to deal with those cases next. May I begin with Raymond, which is page 693. It's a decision of the Secretary of State to make a deportation order on the grounds that it would be conducive to the public good in the interests of national security, which was appealed to the Special Immigration Appeals Commission, SIAC. And for the purposes of our case, the nature and the powers of the Commission are significant. Can I take you to where that's set out in the judgment at page 698, please? This is in the Court of Appeals judgment from Lord Wolfe, but it's a convenient place to start. Lord Wolfe at paragraph 11 identifies the membership of the Commission. One member is required to have held high judicial office. One is or has to have been the chief adjudicator or a legally qualified member of the Immigration Appeal Tribunal. And while there's no statutory restriction as to who's to be the third member, in fact, it has been indicated that the third person will be someone who has experience of national security matters. Again, there's an echo of the Parole Board. We have panel members of the Commission who have particular expertise in the matters that they are dealing with. And at the relevant time, SIAC's task in relation to determining appeals was derived from Section 4 of the Special Immigration Appeals Commission Act 1997. That appears at the top of 699. Subsection 1 The Special Immigration Appeals Commission, on an appeal to it under this Act, shall allow the appeal if it considers, 1, that the decision or action against which the appeal is brought was not in accordance with the law or with any immigration rules applicable to the case, or 2, and this part is important, where the decision or action involved the exercise of a discretion by the Secretary of State or an officer, that the discretion should have been exercised differently, and in any other case shall dismiss the appeal. So the Commission, the law has changed, but at the time of this appeal, the Commission was entitled to form its own view about the circumstances of the case and any threat to national security from the appellant. And that analysis, Lord Wolfe concludes in a section on the standard of proof at page 708, paragraph 42, SIAC were correct to regard it as being their responsibility to determine questions of fact and law. The fact that Parliament has given SIAC responsibility of reviewing the manner in which the Secretary of State has exercised his discretion inevitably leads to this conclusion. Without statutory intervention, this is not a role which a court readily adopts, but SIAC's membership meant that it was more appropriate for SIAC to perform this role. So SIAC in this context is a judicial decision maker with responsibility for determining questions of fact itself, not simply reviewing the Secretary of State's decision, much closer to the role of the board in this case than it might otherwise have been. The first respondent's case is to the effect that Bremen is a very different set of circumstances because the Secretary of State has public policy demands and is a political actor, not a judicial one. But that overlooks in our submission the relatively unusual fact here that SIAC, on appeal from the Secretary of State's decision, formed its own view and determined questions of fact as well as law itself.
Well, it did, but doesn't this decision, certainly once you read all of it, emphasise the deference that is needed to be given to the Secretary of State on questions of national security?
Yes, of course, I don't dissent from that proposition. But the approach that SIAC is required to take in this case, which I'll take the court to in a moment, is an approach which it takes having been required to make its own determinations. It's not simply reviewing a decision of the Secretary of State. Can I turn then to what the Supreme Court had to say in particular about the decision-making process? And can I start, please, with Lord Hoffman, page 733. Right at the bottom of the page, we see a section headed "The Standard of Proof." Paragraph 55 deals with whether one can have a high civil balance of probabilities. That is not an issue which arises in this case.
Well, that's long gone, hasn't it?
Yes. So the civil standard is the balance of probabilities, no more and no less. That comes in, apart from anything else, from in re H, which we'll look at. But there isn't a dispute in this case about what the civil standard means. So I don't need to trouble the court with paragraph 55, save insofar as it sets the scene. But what Lord Hoffman says at 56 is this: in any case, I agree with the Court of Appeal, the whole concept of a standard of proof is not particularly helpful in a case such as the present. In a criminal or civil trial in which the issue is whether a given event happened, it's sensible to say that one is sure that it did, or that one thinks it more likely than not that it did. But the question in the present case is not whether a given event happened, but the extent of future risk. This depends upon an evaluation of the evidence of the appellant's conduct against a broad range of facts with which they may interact. The question of whether the risk to national security is sufficient to justify the appellant's deportation cannot be answered by taking each allegation seriatim and deciding whether it has been established to some standard of proof. It is a question of evaluation and judgment in which it is necessary to take account not only the degree of probability of prejudice to national security, but also the importance of the security interest at stake and the serious consequences of deportation for the deportee. And we say that that is an affirmation of a very similar approach to the one which the board says is the right one for its task, which is not to take each allegation and decide whether it's been established to some standard of proof. It is to take into account all of the material before the decision maker and reach a rational conclusion based on relevant material. That was what Lord Hoffman had to say. Lord Clyde agreed with Lord Hoffman. Can we turn, please, to page 725 from the judgment of Lord Steyne, paragraph 29. Page 725, please, paragraph 29. Counsel for the appellant submitted that the civil standard of proof is applicable to the Secretary of State and to the Commission. This argument necessarily involves the proposition that even if the Secretary of State is fully entitled to be satisfied on the materials before him that the person concerned may be a real threat to national security, the Secretary of State may not deport him. That cannot be right. The task of the Secretary of State is to evaluate risks in respect to the interests of national security. And there's then a quote from what Lord Wolfe said at paragraph 44 of the Court of Appeal judgment. Rather than I read it all out, can I ask the Court to read the rest of paragraph 29, please, including that quote? We set broadly the same approach as Lord Hoffman and Lord Clyde, which is that one must not only look at the individual allegations and ask whether they've been proved, but to examine the case as a whole and look at the cumulative effect of all the material when assessing risk.
Well, if that's right, then you are looking at questions of proof in relation to past events. But you're not confusing that with applying a standard of proof to the existence of a future risk. They're two different things, aren't they?
I respectfully agree, my Lord. One is looking at past events. The panel has to look at past events and decide what it makes of them. The difference between the Court of Appeal and the first respondent and what the board submits in this case is whether allegations or pieces of evidence have to be disregarded as soon as they fall below 50%.
Yes, no, I understand that. But in Raymond, the passage that you've just shown us from Lord Steyne is about the error that is involved in applying the concept of a burden of proof to assessing future risk, isn't it? It's not about an error in applying a concept of burden of proof, or standard of proof, to what past facts existed.
Well, in my submission, it's both.
Well, yes.
In my submission, it's looking forward and saying that the task of the Secretary of State and of SIAC in this case is to assess risk, which is not a matter for which the burden of proof is helpful.
Yeah.
But looking backwards as well, the passages from Lord Wolfe, Lord Steyne and Lord Hoffman all say that one isn't simply limited to looking backwards and assessing whether individual pieces of evidence meet the civil standard and are therefore proved.
Yes, I see.
They say it's necessary to go beyond that and look at all of the material taken together.
Yes, thank you.
Page 736, please. Lord Hutton. This is a short passage. Paragraph 65. Agreeing that the Secretary of State was concerned to assess the extent of future risk, he was entitled to make a decision to deport on the ground that an individual is a danger to national security, viewing the case against him as a whole, although it cannot be proved to a high degree of probability that he has carried out any individual act which would justify the conclusion that he is a danger. It's the same point. We leave out of consideration the high degree of probability. We don't need to worry about that. It is not necessary to prove facts to the civil standard in order to reach the conclusion. The last judgment that I should take you to of that of Lord Slynn, which is closer to the approach of the Court of Appeal in this case. Paragraph 22, which starts right at the bottom of 723. Here, the liberty of the person and the opportunity of his family to remain in the country is at stake. When specific acts which have already occurred are relied on, fairness requires that they should be proved to the civil standard of proof. And I accept that that sentence might be taken to support the approach of the Court of Appeal, albeit that it's inconsistent with the other four justices. But Lord Slynn does go on to say, but that is not the whole exercise. Goes on to say that the Secretary of State, in deciding whether it's conducive to the public good that a person should be deported, is entitled to have regard to all the information in his possession about the actual and potential activities and the connections of the person concerned. He is entitled to have regard to precautionary and preventative principles rather than to wait until directly harmful activities have taken place. In doing so, he is not merely finding facts but forming an executive judgment or assessment. There must be material on which proportionately and reasonably he can conclude there is a real possibility of activities harmful to national security. But he does not have to be satisfied nor on appeal to show that all the material before him is proved and his conclusion is justified to a high civil degree of probability. That passage seems to me to be something of a hybrid, perhaps, between what the other four justices have indicated and what the approach the Court of Appeal has taken in this case. It does, I accept, identify that where past facts are relied on, fairness requires they should be proved to a civil standard of proof. But His Lordship rather rose back from that in the passage which follows. And he accepts in terms that there must be material on which it can reasonably be concluded there is a real possibility of activities harmful to national security. And a conclusion in terms he does not have to be satisfied that all the material is proved to the civil standard. At its lowest in our submission, the judgments in Raymond tell us that the Court of Appeal and the first respondent are wrong to assert that it is always necessary to comply with the requirements of fairness to base decisions on facts found to the civil standard. Not in every case. We know it's not, because this court has found it was not necessary in this particular context. Now, we go further, of course, than that, and we say the reasoning in Raymond is applicable to the present context, and I'll come on to that. But at a more fundamental level, it illustrates that the proposition put in stark terms in the Court of Appeal's judgment and in Malone and Friends' case, that fairness simply requires that only facts found on the balance of probabilities can be relied upon. They show that that's wrong. But I should deal, before I come on to the position of the board, specifically with Begum, which is the other case which deals with this issue, and it's at a case that starts at page 978. But the parts of the judgment which I'm going to take the court to start on page 1003. No doubt the court will be aware this was a case of deprivation of citizenship on grounds of national security. Raymond was considered from paragraph 51 onwards, that's page 1003. And a number of the passages that I've drawn to the court's attention are set out there, and I don't want to repeat that. Can I ask the court please to turn to page 1005, paragraph 59. Where Lord Reed, although this is a judgment of the unanimous judgment of the court, said analyses the approach taken by Lord Slynn and the other members of the House of the court in Raymond, and he says that a contrast might be drawn between the hybrid approach favoured by Lord Slynn, as it might be described, under which some facts had to be proved on a balance of probabilities, and the evaluation based on the facts had to be reasonable, and what he describes as Lord Hoffman's more orthodox, in public law terms, identification of the relevant questions as being firstly whether the Secretary of State's evaluation had a proper factual basis, or as he also put it, whether there was no factual basis for the Secretary of State's opinion, and two, whether the Secretary of State's opinion was one which no reasonable minister could have held. He says that Lord Steyne and Lord Hutton expressed agreement with Lord Slynn. That's right, although you'll see what else they said, and it appears that they at least read his judgment, as far as they agreed with it, as taking the approach that the board identifies for your lordships. Lord Clyde and Lord Hutton expressed agreement with Lord Hoffman. Whatever conclusion one might draw as to how the law stood at that time, the subsequent repeal of Section 4 indicate it's Lord Hoffman's approach which is now the more relevant. And what that means is that SIAC lost its power when Section 4 was repealed to find facts itself, so the determination very much became a more traditional judicial review analysis. Of course, that does support the proposition that when we look at Raymond, we look at that very much on the basis that SIAC, as judicial maker, was not operating on that traditional judicial review basis. And he concludes by saying, as Lord Wolfe observed in the passage, which I've read to your lordships, the express powers conferred by Section 4 were the basis for attributing to SIAC a role which a court would not readily adopt. So the statutory context there was to require SIAC to take decisions on the facts. The statutory context in this case, of course, requires the board to take decisions on the facts. So we say it's clear that there are some contexts in which a process of risk assessment will be lawful in public law terms, where the expert decision maker relies on factual matters which have not been proved on the balance of probabilities. And we say that demonstrates that the approach in re H, taken from the family context, which the Court of Appeal applied in this case, but that approach is not of universal application to all public law or judicial decisions. Can I turn then to in re H? It starts at page 527. It's a case about the approach to be applied by a court considering whether to make a care order or a supervision order pursuant to Section 31 of the Children Act 1989. And we've got the relevant statutory provisions in a couple of places, but perhaps I should start with the judgment of the opinion of Lord Nichols on page 547, which is the majority opinion. At D on 547, Section 31 of the Children Act 1989 empowers the court to make an order placing a child in the care of a local authority or putting a child under the supervision of a local authority or a probation officer. Section 31(2) provides that a court may only make such an order if it is satisfied, A, that the child concerned is suffering or is likely to suffer significant harm, and B, that the harm or likelihood of harm is attributable to, 1, the care given to the child, or likely to be given him if the order were not made, not being what it would be reasonable to expect a parent to give to him, or 2, the child's being beyond parental control. And the majority of the House in this case held that a decision under Section 31(2) could only be taken after finding facts to the civil standard. And so you can see that conclusion in Lord Nichols' judgment. And we turn, please, to page 554. Starting...
Sorry, Mr. Quinn, can I just stop you there? You stand.
Drifting to the right.
Okay, I understand. Thank you.
All right.
Would you like another lecture to put that one to?
That's fine. Thank you. Page 554 at B, 3 lines into the paragraph, the court's conclusion must be founded on a factual base. The court must have before it facts on which its conclusion can properly be based. That is clearly so in the case of the first limb of Section 31(2)(a). There must be facts proved to the court's satisfaction if disputed, on which the court can properly conclude that the child is suffering harm. An alleged but non-proven fact is not a fact for this purpose. And that, of course, is very much the approach of the Court of Appeal and the first respondent in the present appeal. There must be facts from which the court can properly conclude there is a real possibility that the child will suffer harm in the future. Significantly, the explanation that Lord Nichols gives for that conclusion is very much grounded in the wording of the statutory provision which is being considered. So at D, he says there are several indications in the Act that when considering the threshold conditions, the court is to apply the ordinary approach of founding its conclusion on facts, and that nothing less will do. The first pointer is the difference in the statutory language when dealing with earlier stages in the procedures which may culminate in a care order. And one can see there under Part 5 of the Act, the local authority is under a duty to investigate where they have, quotes, reasonable cause to suspect. Between E and F, the police may take steps to remove or prevent the removal of a child where a constable has, quote, reasonable cause to believe. And at G, Lord Nichols notes that in marked contrast is the wording of section 31(2). And at the bottom of the page, this is the language of proof, not suspicion. At this stage, more is required than suspicion, however reasonably based. So we are undoubtedly firmly grounded in the Children Act, and as we go over the page to 555, firmly grounded indeed within section 31(2)A of the Children Act, because His Lordship says that the next pointer is that the second threshold condition in paragraph A is cheek by jowl with the first. So this is an exercise in statutory construction.
But at 553, before we get there, he sets out various general propositions, doesn't he?
He does. I accept that. And his starting point, of course, is that courts act on evidence and reach their decisions on the basis of the evidence before them. But there is no doubt that when he comes to express his conclusion as to how 31(2)A should be interpreted, his interpretation is heavily informed by the structure of the Children Act and the wording of the relevant sections. So although there's a general introduction, if I can put it that way, the judgment does not purport to suggest in my submission that the approach to section 31(2)A of the Children Act is one which must apply in any public law or judicial decision-making context. And the context of the Children Act, and it's perhaps obvious to say that it's very different from the context that we're looking at, but that's worth just exploring a little bit, because although a panel of the Parole Board considering release and a court hearing an application for a care order are both making assessments of future risk, although there's that similarity, the decision that they have to take is quite different in nature. And one particular feature of the process I draw to the court's attention, that, as we've heard, the purpose of the board is the protection of the public, not the welfare of the prisoner. The purpose of the court considering whether to make a care order is the protection of the welfare of the child. But that can point in two different directions, because welfare may be, or the court has to consider the risk to welfare arising from leaving the child with parents who may cause harm. But on the other side of the coin, the court will consider the risk to the welfare of the child arising from separating the child from his or her parents. And there are countervailing considerations. So it's a balancing act in a way that the decision of the Parole Board, as has been identified already, is not a balancing act. There's a further difference, which is that it's acknowledged that there is a burden of proof on the local authority in this context, for your reference 549H. And the difference in statutory and practical context was recognised in a passage that I may have taken you to right at the outset of my submissions from Mr. Justice Elias in Sim, where he rejected a submission that disputed facts must always be resolved by the board by hearing primary evidence. Yes, I have taken it to you already. It's paragraph 60. I'll just give you the note rather than read it out again. Page 1409. In re H was affirmed by the House of Lords in another case called in re B. And I just need to touch on that briefly. Page 782, please. This is another judgment of Lord Hoffman.
Sorry, page number again?
The case starts at 776 and Lord Hoffman is at 782, please. By way of introduction, paragraph 2, Lord Hoffman addresses the question of proving of facts. That's a matter which I addressed the court on much earlier in my submissions. Invite the court to note something similar is said there. But the important part for the present part of the argument is paragraph 3, where he says that the effect of the decision of the House in re H is that section 31(2)A requires any facts used as the basis of a prediction that a child is likely to suffer significant harm to be proved to have happened. Every such fact is to be treated as a fact in issue. The majority of the House rejected the analogy with facts which merely form part of the material from which a fact in issue may be inferred, which need not each be proved to have happened. There's, of course, no conceptual reason, Lord Hoffman said, for rejecting this analogy, which in the context of some predictions, and I'm going to come back to Lord Brown-Wilkinson in a short while, in the context of some predictions might be prudent and appropriate. But the House decided it was inappropriate for the purposes of section 31(2)A. It is this rule which the House reaffirms today. So Lord Hoffman confirms that the minority in approach in re H may be appropriate in other contexts, but the House of Lords was satisfied that it was appropriate in the context of section 31(2)A of the Children Act. It is very clearly not saying that the approach in re H is necessarily, and as a minimum requirement, applicable across the board to all public law and judicial decision making.
So which paragraph are you referring to there, please?
That's my submission based on paragraph 3, my Lord.
Okay.
The next case in the bundle is called In Re J. It starts at 804. It was a case where a problem arose from the fact that it was impossible to say whether injuries to a first child had been caused by either the mother or the father. And at page 866, Lord Reid, with whom Lord Clark and Lord Carnworth agreed, said at paragraph 93, I see the attraction of the view that the approach to the interpretation of section 31(2)A of the Children Act adopted by the majority in re H was overcomplicated and has had unfortunate consequences. And he says at the end of that paragraph, nevertheless, it's too late to reconsider the decision in re H. The view of the majority has been followed in two later decisions at the highest level and must, in my view, be treated as settled law.
Yes, that's in the context of the problems that you get into when you've made a finding that it was either A or B.
Yes. It is, and that's not a problem which we need to address in this appeal. But it lends, I don't say it's a dictum of the greatest importance for this appeal, but it does lend further weight to the proposition that in re H is not a lodestar by which all judicial and public sector decision making should be guided. So we say that this court should have real caution before reading in re H across two other contexts. And before you consider placing any weight on the reasoning in re H, it's important to have regard in our submission to the minority opinions of Lord Lloyd and Lord Brown-Wilkinson. Can we look first, please, at Lord Lloyd, starting on page 544. At 544C, paragraph begins, I now return to the second half of section 31(2)A. It requires the court to be satisfied that the child is likely to suffer significant harm in the future. There's nothing in the second half of the subsection which requires the court to make a finding about anything in the past or present. The finding of future risk must of course be based on evidence. It cannot be based on hunch. If there is no evidence to support a finding of risk, the finding will be set aside. But if there is such evidence, then a finding may be made even though the same evidence is insufficient to support a finding of past fact. And at 545G, he gives this example. Suppose, for example, there are 3 or 4 matters for concern which have led the social services to the belief that a child is at risk, on each of which there is credible evidence, supported it may be by evidence from a child psychiatrist, but suppose the evidence is insufficient on any of them to justify a finding that the child has been abused. Is the court powerless to proceed to the second stage? That is not what Parliament has said, and I do not think it is what Parliament intended. Parliament has asked a simple question: is the court satisfied that there is a serious risk of significant harm in the future? This question should be capable of being answered without too much over-analysis. And continues over the page, 546, right at the top. In an unusual case such as the present, which has been fought on the basis of a single issue of past fact, it will no doubt make sense for the court to start by deciding whether that issue has been proved to its satisfaction or not. But this is only the beginning. Even if the evidence falls short of proof of the fact in issue, the court must go on to evaluate the evidence on that issue, together with all the other evidence in the case, and ask itself the critical question as to future risk. And we say that captures neatly the proper approach to be taken by a panel of the Parole Board. Lord Brown-Wilkinson's opinion starts on page 536. And the example of the air raid warnings is right at the bottom of 536. And I won't read it out, it's set out in our case. The important parts of it, we say, are that, on his analogy, they could not, on the balance of probabilities, have reached a conclusion that any one of those sightings was of an enemy aircraft, nor could they logically have put together 5 non-proven sightings so as to be satisfied that enemy aircraft were in fact approaching. But the question was whether there was a risk, and the facts relevant to the assessment of the risk were the reports, not the truth of the reports. They could well, on the basis of those unconfirmed reports, have been satisfied there was a real possibility of an air raid and given warning accordingly. And the approach of Lord Lloyd and Lord Brown Wilkinson, although plainly it does not apply to applications under Section 31(2) of the Children Act, helps to explain in our submission why the board's approach in this case is the right one and why the Court of Appeal's criticism of the guidance is misplaced. And that's going to lead me, after the short adjournment, to the application of those authorities to the Parole Board. Before I do that, there's just one point of detail which I need to address, and that's the reliance of the first respondent on a case called In Re D, which is a Northern Ireland case in which the House of Lords applied In Re H to the Northern Ireland equivalent of the Parole Board called the Life Sentence Review Board. And I can deal with that very briefly in the few minutes before we get to 1 o'clock. Because it's right that In Re D does apply In Re H, but it does not apply the part of In Re H which we're concerned with in this case. It deals with the proper approach to the civil standard of proof, whether there is a single standard on the balance of probabilities or a higher standard which should be applied. And as my lords said, that issue's since been resolved. But it's not the part of In Re H which we're concerned with. The parts of In Re H which are material to this appeal, the parts that I've just made submissions on, are not addressed by In Re D. And our submission is that that is not a case which assists the court in determining this appeal. Well, that concludes the second part of the three parts of the submissions that I indicated I proposed to make. We're just coming up to 5 to 1. I don't know if it's more convenient for us to break now than for me to start on part 3 for 5 minutes. I'm in the court's hands.
That is fine. Could I just refer you to one case? It may not be of assistance, but you were talking not just in the field of public law, you were arguing that In Re H didn't apply across wider judicial decision-making. And the case which might support that proposition was a case that this court heard in 2020 called Shadang Shipping. I don't know if you know of its existence. It's 2020 UKSC 34, and the discussion around paragraph 97 of that judgment. You might want to look at it over the short adjournment.
My lord, I'm very grateful. We'll do that.
Or the court will now adjourn.
Collins, just before we go, can I just flag up a question which I would like to ask later, and it might help you to have time to think about it. Are you going to get to some concrete examples of the kind of situation that the board may have to cope with,
yes,
where there are allegations made? And will you perhaps be able then to help us on why the guidance doesn't, whether it means to or not, why it doesn't tend to encourage a no smoke without fire form of thought?
Yes, the plan is, as I said, the part 3 of my submissions is to look at the work of the board itself, and yes, I will deal with examples.
Thank you very much indeed. That'll help me anyway.